Mr. Pasternak, go ahead. Let's get into we'll start with item number 24. Open that up, please.
Yes, Mr. Chairman. Item number 24 is impound I-4613. The impoundment pursuant to NRS 706.476 of a vehicle registered to Stephen Barnes for possible action.
Okay, thank you so much. Mr. Ferendorf, welcome. Would you introduce yourself and spell your last name for us?
Absolutely, thank you. My name is John Ferendorf. Last name is spelled F as in Frank, Ahrendorf. And, you know, I do appreciate the commissioners allowing this to trail a bit. I apologize for being late, but I'm happy to be here. Now, I know that there's a big discrepancy between the way that Mr. Barnes interprets interstate and intrastate travel as compared to from dealing with the way that the NTA interprets them. And so I want to just start off by saying I understand that there is a clear difference of opinion on this. However, I've spoken with the folks at J.J. Keller who essentially put together the guidelines, the federal guidelines as far as defining interstate and intrastate travel, especially when a ticket is prearranged and pre-booked. It's a very small carve out, but under the federal guidelines, they interpret that as being a air travel that comes from outside of the state, that lands inside of the state, and then someone is picked up. It does not matter if they are dropped off inside of the state or outside of the state. As far as the way that the folks who put together the federal guidelines, they interpret that to be interstate travel. And so there's also a carve out as far as it goes for medical transportation. And because of that carve out, the folks at J.J. Keller who do this at a far higher level than I do, they would interpret this to mean that this is interstate travel and that this particular case is a legally valid travel as far as interstate travel is concerned, which would be the federal guidelines and under the US DOT license. And so with that considered, I understand that there are differences of opinion here, but that is really where Mr. Barnes is coming from, especially with the nature of this trip being the medical transportation.
Okay, thank you, Mr. Ferendorf. So, commissioners, I'm going to jump in here because I've looked at this case. I happen to know a little bit about some of the circumstances, and I also I've talked to 3 separate people, and I did this on an individual basis, so they were not discussing it with one another. 2 agreed on one side, one disagreed on another side. So here's what they came up with, and here's how it was explained to me. So first of all, this was a scenario where there was an aircraft that came in for the harvest of organs, and I say harvest, I should not use that term. It's the procurement of organs. And it's a very delicate situation. I know this very, very well. I have a family member who has had 2 organ transplants, was on the UNOS list at one point, so I'm very, very familiar with how even the patients have to be ready to, at a moment's notice, to get to a transplant facility. This is very near to my own family. And these procurements are critical in terms of time. So the way it's been explained to me that these air medic planes, these aircraft, the flight crew is a dedicated flight crew for organ procurement. And so they come in and they fly into a particular city, they procure the organs, and then they fly out. Now, if you look at the UNOS zones, we're part of the western zone. It's like zone 5, if memory serves me correctly, which there are 5 states in zone 5. So it's a very, very large zone of that for UNOS. And don't quote me on any of this because I'm going off of memory from when our family member was transplanted the first time, which was 2008, and then the second time was 2023. I happen to be very blessed because both were live donors, family members, just incredible. But I digress. The point here is that the people that I talked to said that two of them felt that the first leg of the trip was actually an interstate trip. So they called it, part of the flight duty period, that when that team flew into town, the actual destination was the hospital. Now, those two that I talked to felt that we had interrupted Mr. Barnes' ability to actually commit a crime because we didn't let him complete that trip by picking them up from the hospital and taking them back to the airport, which would have constituted intrastate in their opinion. The third person that I talked to said that no, both sides were interstate. So there's obviously some confusion on this. But because of that, I'm not personally going to support item number 24. I think out of an abundance of caution, given the circumstance, that we should dismiss I-4613, the 706.476. So those are my comments. Commissioners.
Chair, was your request to dismiss it?
I'm sorry?
What was your request again, Chair? I'm sorry, I didn't catch all of it.
My request was to dismiss I-4613 because I believe that at least the first leg was an interstate leg. Again, the way that it was explained to me by folks who are very familiar with US DOT guidelines and FMCSA guidelines, felt that at least that first leg was part of the flight crew's flight duty period. And then the other piece of this, by the way, is that we didn't get any photographs of the passengers. We didn't get any interviews of the passengers for obvious reasons. I mean, no interviews because look, they're on a mission, and I get that part of it. But we hopefully could have at least gotten photographs. So, again, out of an abundance of caution, I'm not going to support item number 24.
Mr. Chairman, would I be able to address the issue on behalf of?
Absolutely, you bet.
Thank you so much. So I want to go through some of this in the analysis. First, I would begin with agreeing with you, that is, there's two legs of this journey. There's one leg where the travelers were transported from the airport to the hospital. And then there's a second leg where the travelers were about to be transported from the hospital back to the airport. The reason the vehicle was impounded is not because of transportation that occurred from the airport to the hospital. The reason the vehicle was impounded because of the transportation that was going to take place from the hospital to the airport. In fact, the billing records of the respondent show that these passengers have paid for the transportation back. And as Mr. Chairman knows, I have Jason Brown, your investigator. As the chairman knows, our investigators regularly impound vehicles when somebody's ready, willing, and able to provide transportation illegally in the state of Nevada point to point. So even if I were to agree with those two of those three people that were secretly advising you, the respondent was not impounded for the transportation that occurred from the airport. The respondent was impounded for the transportation that was going to occur from the hospital to the airport, and that is consistent with staff's position on this issue. Hundreds of impounds have been done in this particular matter by the agency. On the second item that I would like to address is an opinion. I can have an opinion about this matter. The respondent's legal counsel can have an opinion about this matter. The three people you spoke to can have an opinion about this matter. J.J. Keller can have an opinion about this matter. There is only one opinion that counts, and that is the opinion of the person who's wearing a black robe. That is Judge Hicks. We have litigated this exact matter before the federal court in the Ninth Circuit, before Judge Hicks. Let me read what he said in his opinion. On page 9 and 10 of his opinion, Judge Hicks wrote as follows: still trips for out-of-state business and vacation travelers booked by travel agents and other third-party companies, and trips prearranged and paid for in advance by the passengers constitute intrastate travel property regulated by the NTA. There's no ambiguity in Judge Hicks's decision. That has been appealed to the Ninth Circuit. The Ninth Circuit Court of Appeals upheld that decision. It was appealed to the United States Supreme Court. The United States Supreme Court refused to take certification. So that is the law of the Ninth Circuit. Now, just because J.J. Keller wants to rely on a case from Colorado, which is in the 10th Circuit, we're not governed by the laws of the 10th Circuit. So as far as I'm concerned, we have to follow on behalf of staff what the Ninth Circuit Court judges have told us, and that's what we have done in this case. Thank you very much.
Thank you, Mr. Zoka.
And Chairman, if I may add just something as well.
Go ahead, Ms. Wilburn.
Thank you. Administrative Attorney Yemi Wilburn. I would just state, we are a state regulatory agency. We are sovereign and separate from federal guidelines, and we interpret our laws based on us who are hired to do this job, not consulting with people who don't work with us and people who are not tasked with our laws, with applying our laws, with regulating our laws. So I would just caution using those people as to rely on as to how our laws should be interpreted, because they are not familiar with our laws. They are familiar with federal laws. We do not apply the federal laws. We apply the state laws, and that is what our agency is tasked with doing. Judge Hicks' opinion is extremely clear, and he spoke directly to our laws and how they are supposed to be applied. So that's all the advice I give the commissioners in this case when trying to render a decision.
Okay. All right. Thank you so much. Mr. Ferendorf.
Just as a point of clarification, as to that procedural history, Judge Hicks was rest in peace, was a district court judge here in Washoe County. And so it is inaccurate to say that Judge Hicks sits on the Ninth Circuit. Judge Hicks is a district court judge.
I never said that.
Hold on.
I never said.
Hold on, Mr. Zoka. Please, let's not interrupt. Please.
And as to the Ninth Circuit upholding that decision, that's inaccurate as well. The Ninth Circuit did not take it up. And so there has been a district court ruling from a district court in Washoe County that indicates that that is how they interpreted it at that court. But this was never in front of the Ninth Circuit. They did not take it up, and it did not go up to the Supreme Court. So it is just an inaccurate statement as to where these decisions have been made. Judge Hicks's opinion was not upheld by the Ninth Circuit. The Ninth Circuit did not take it up. And so there was no decision that was rendered on at the appellate level. Now, in addition, though I do understand Ms. Wilburn's position where she's coming from and saying that this is a state law, and this is a state agency and that this is where we're coming from. At the same point in time, Mr. Barnes has a USDOT license, or a USDOT license, and as such, that is governed by the federal regulations. And though I do understand that there is a major difference between those two areas of law, he is operating, as far as USDOT is concerned, this would have been an interstate trip, the entirety of it.
Thank you, Mr. Ferendorf. Mr. Zoka, go ahead and respond.
Well, I think what I'm hearing is misapprehension by counsel for respondent. Perhaps he's not as familiar with the case history as I am. I have litigated this matter all the way to the United States Supreme Court. The United States Supreme Court refused to take certification of the matter. And in fact, I'm looking right now at the decision of the Ninth Circuit, and it says in bold letters, Judge Hicks's decision is affirmed. It says it's affirmed. And I never said that Judge Hicks worked the Ninth Circuit. He was a Washoe County District Court judge. Now, on the issue of the federal regulations, we have not adopted those federal regulations on which respondent intends to rely. We have only adopted a discrete set of federal regulations that govern vehicle safety, that govern driver safety. We have not adopted those federal regulations. I would also note that within the federal code, it's clear that federal agencies have carved out the airport as something they don't want to regulate. It's in their statute. So if we were to accept the interpretation that's being proposed here by respondent, you would have a Wild West at the airport, because the federal government in their own statutes doesn't regulate it. And now under the interpretation that's being promoted here, we're not allowed to regulate it. So that's also a red herring here. So those are all the comments I have. Thank you very much.
Thank you so much, Mr. Zoka. So hold on just a minute, Mr. Barnes. So it's interesting that you say that we didn't adopt those particular federal regulations. So what do we need to do? Do we need to hold a hearing, have an agenda item to adopt those types of federal regulations, or what's the process, Mr. Zoka?
You're not required to adopt those federal regulations whatsoever. And I would also note that there was a recent Supreme Court case. The name of the case escapes me. For that, I apologize. But what the United States Supreme Court said is that judges, not administrative agencies, judges are the final arbiters of what is required under statutes and regulations. So regardless of what may be in those CFRs on which respondent counsel tries to rely, which we have not adopted, Judge Hicks's decision as a judge interpreting this particular issue about the airport trumps whatever may be in those CFRs. Thank you.
Okay. So I was under
the recent United States precedent.
I was under the impression that we had adopted the CFRs through NAC 706.2473, if memory serves me correctly. So, Mr. Barnes, go ahead.
Yeah, a couple of things. First off, all states are required to accept the 49 CFR. It's not an option. You must know it, you must have training for it, you must adopt it. States typically take the same thing and they put it in for their interstate transportation with minor modifications generally. You might call something a chair versus an authority, things like that, but nothing really material. So you're not allowed, and we all know that there's a U.S. Commerce Clause, part of the Constitution. There's also the Supremacy Clause that states can't come in and do these things willy-nilly. In fact, Nevada is the only state in the nation, by J.J. Keller's testimony to me, that violates federal law. The only one. So either they've said all the other 49 states are wrong and Nevada is right, or Nevada is wrong and the other 49 states and the federal government are right. And when Mr. Zoka talks about a wild, wild west scenario, that's absolutely not true. Less than 1% of all the transportation that comes into and out of that airport is pre-booked and pre-arranged. That's what we're talking about. We're not talking about anything. Once those people have touched the ground, that's now interstate. You can come in from the same city on the same flight. If Mr. Farendorf books his flight, or he books his transportation before the flight lands, and Mr. Hartung tries to book his once the wheels hit the ground, we cannot take him. It's only pre-booked, pre-arranged. And there's many reasons for this. It could be security reasons. We drive some of the highest dignitaries you can imagine, the background checks, the things that they have to go through. I won't mention names, but they're presidential family members and things like that we've had to be accredited for. And then there's things like, okay, you take them from, let's say, the KTVL airport in South Lake Tahoe to Edgewood. The next morning you show up to take them back, and suddenly you found out that the weather changed, and somebody very high level says, oh, I'm sorry, our plane was flown from KTVL to Reno, can you take us there? How do you say to that person, geez, I can't do that? as they're getting in your car. So that's why pre-booked, pre-arranged transportation is so important. Also, there's been many instances, we pick people up, let's say they're supposed to go to the Marriott Timber Lodge in South Lake Tahoe, California. Their plane's 2 or 3 hours delayed, we pick them up. On the way down there, they get a call. Hey, guess what? We're having dinner in In-Kind Village. Can you just come there and then we'll give you a ride down to your hotel? What do we say to that customer? I'm sorry, we must kidnap you, now that we're halfway there and the call comes in, and must take you there, or if we take you to where we're supposed to go, if we're followed, then we're gonna get impounded. You put us in these very, very bad positions that's not good for the state. We're an embarrassment across the state.
So I'm
I have a
gonna,
couple other things to say too.
I'm gonna cut you off there because that's not what
Oh, yeah,
we're here to talk about. Item number 24.
Okay, so I want to get I'll get back to that.
So
I have one more important thing to say.
let's. I want to stay on task.
I have something really important to
So
Mr. Arthur.
go ahead, Mr. Barnes.
Okay.
Go ahead.
So the one thing that's different on this one is for the medical, okay, the FAA also weighs in on top of US DOT, and I want to read this to you. Under federal law, transportation laws like fair labor standards and such, those involved in organ transport are recognized as participating in interstate commerce, even if specific flights are within a single state. This is because aviation is regulated at the federal level, and organ transplant missions are often scheduled with little notice and span multiple states, creating a continuous and integral link in interstate commerce. So I could go on, but the point is what the FAA is saying, even if this came in from Vegas, which it did not, and even if it was going from Vegas to the Reno Tahoe airport and then to Renown and then back, that would still be considered interstate transportation. And I can give you this if you'd like to see it.
No, that's okay.
Okay.
That's all right.
But that takes it even further.
So from my perspective, and I'll just reiterate this one last time. I believe that, and while I don't think I agree with you, Mr. Zoka, on the fact that we should impound people on the premise that they might commit a crime. That's difficult. And so while I don't disagree that Mr. Barnes likely was going to take them from the hospital back to the airport, my personal belief is that he needed to commit that. That would be like me sitting out front of a bank with a gun and I get arrested for bank robbery, when I did not rob the bank. I just had a weapon. So it's a little murky for me. I'm not a judge. I don't wear a black robe. We know that. I'm not even pretending to be a judge, and I didn't stay in a Holiday Inn Express last night. But for those reasons, I believe that in this particular case, I believe that medic crew was part of the flight crew, and at least that first leg was a continuation of that journey, and therefore I'm not going to support item number 24. So anything further? Do we have any public comment?
Mr. Chairman, my comments are not so much directed to you. They're more directed at the respondent.
That's okay.
Earlier, I referenced the case about where the Supreme Court has said that courts don't have to defer to agencies' interpretation of statutes, and that was a Loper decision, 603 U.S. 369. I just wanted to mention, since I threw out the case without actually referencing the actual case. The other thing I would like to mention is that I do have investigator Jason Brown here, and I can tell you, as your chairman knows, we don't prosecute these as crimes, but in fact, impounds are performed before the ride is actually taken. So we have done hundreds of impounds before the ride is actually taken of individuals who are ready, willing, and able to provide that transportation. And if you'd like to hear more information,
No.
So Mr. Zoka can certainly provide that to you.
No, that's not necessary, Mr. Zoka. But what has happened in the past, and what I believe occurs, is when an enforcement officer is part of that and negotiates the ride. This particular second leg of the ride was never negotiated by the enforcement team. It was something that was negotiated by a third party. So again, I'm just, all I'm suggesting is that I'm not going to argue the merits of the case with you. I'm not a lawyer. I'm not trying to be a lawyer. I've read this. I have a lot of discomfort. I think that out of an abundance of caution, for me personally, I'm not going to support this. And so, that's just as I've read the investigative report, I've looked at the facts in the case. There's some ambiguity here. And I believe in just in the same terms that you have used with me, and this is not meant in the pejorative, out of an abundance of caution, I am not going to support this particular item. So, yeah, go ahead.
Mr. Chairman.
Go ahead.
Administrative Attorney Wilburn, I just need to clarify something. You're apparently you're under the impression, and I know you don't know operations down here in Las Vegas as well, and you're just not here. That's not correct that the enforcement officer needs to themselves negotiate the price. Our enforcement officers down here patrol the strip on a daily basis, and they perform impounds of vehicles where they overhear the solicitation between the passengers and the drivers themselves. They are not even part of the negotiations. It's the fact that there was a solicitation that happened, that it was a ride for cash, and that they observed it happening, and they impound those vehicles. So the enforcement office actually does not need to be part of the negotiations for the price of the vehicle. So I needed to make that, and that is perfectly legal and perfectly sound, and that's exactly how it's done up here. Furthermore, with Mr. Barnes saying that the prearranged takes it out of the intrastate, that's exactly in opposition to what Judge Hicks ruled, where he said prearranged and paid for constitutes intrastate travel. So Mr. Barnes is just wrong. So, and that's the legal opinion, case law, and the way it works in the legal world is case law rules.
Okay.
It's not the opinion person or another.
No, and look, Ms. Wilburn, that's okay. Again, there are some other extenuating circumstances that this is a medic flight crew. That's what gives me discomfort in this particular case. If this was a group of tourists where someone had been injured and needed to be taken to Renown to be treated before they were taken on to their destination, I'd probably question it. This is a very different scenario. This is a very unique situation, and that's where the discomfort comes from me. This one is different. I'm not trying to paint this as a perfect situation, but I feel that there are some extenuating circumstances that I cannot support. That's all I'm suggesting.
Correct, and I'm not saying, Chairman, Administrative Attorney Wilburn, that you need to support. I'm just trying to make the record very clear, as the record in this case is important, as Mr. Barnes has stated he might pursue further litigation, so this record will be used.
Okay.
There is, you keep referring to it as a flight medic crew. Let's be very clear. This was not an air ambulance, this was a Learjet, and this happens lots of times where very, very wealthy hospitals will send a Learjet, and they're not a medic crew, a flight medic crew, in the sense that this is not their job. These were surgeons sent to procure an organ. Their job is surgeons. They operate in a hospital. Their job is not to fly back and forth on a plane. There were 2 pilots on this plane. That was the crew. They were in official uniform, and they were taken away by a certified carrier. So nobody that was of the flight crew got it to Mr. Barnes' vehicles. That needs to be.
So I didn't read that the flight crew. I must have missed that because I didn't see that they were dressed as pilots or any of that. I didn't see that in the report, and I certainly didn't see any photographs. So again, that's my opinion. So, Mr. Ferendorf, anything else from you, sir?
I believe that nothing further. In all honesty, I believe that with the amount of ambiguity and on the basis of it, that dismissal would be appropriate.
Okay.
Okay, can I say something?
Yes, go ahead, Mr.
Well, once again, this the FAA has stepped in on this one, and they have given even more credence to it and taken this out. Whatever disagreement we have about pre-booked, pre-arranged transportation that we believe is correct, and someday we'll find that out, we'll go far enough up to do that, I'm confident. But this one, because it's medical, And by the way, everybody says surgeon. I'm the only one that knows who was in my vehicle. It's ironic. You have all these enforcement officers. They don't even know how many people I had in my vehicle. They don't know who their names were. They don't know what they have no idea that was in my vehicle. They don't. I do. I did not have surgeons in my vehicle. I had a flight attendant that was babysitting the machine. These machines are multi-million-dollar machines that have to be monitored the entire time in that aircraft. Okay, and then when it's brought out, they're monitoring it the whole way. And when they get the organs out, they're also monitoring it the entire way. So, and these people only work for transmedics. They do not work for anybody else. So there's a whole lot of stuff that was not done in the investigation level. And I'll just throw this out parenthetically. If the first part of that trip was considered interstate, and it was, aside from everything else, the FAA says it is. The FAA, even if it was coming from Vegas and going back to Vegas, then why would the second part of the trip be any less legal than the first part of the trip? Because we're assuming that the second leg was illegal and the first part was legal. The FAA, forget USDOT, forget Federal Motor Carrier Safety Administration. We're talking about the FAA, the Federal Aviation Administration says, when it comes to organ transplants and medical personnel and equipment, that this is considered interstate. That would apply to both the first leg and the second leg. So it's preposterous to then say, well, the first place was this and the second leg. It doesn't matter. It's irrelevant. It's all legal. And if you don't believe me, check the FAA regulations. I've got them right here. I'll be happy to show them to you and share them with you.
Okay, thank you, Mr. Plains.
Thank you.
Okay, any other comments on this matter?
Chair, if I may,
Yes, go ahead.
I happen to have some experience in this space, being that for 19 years, just about, I've done enforcement. And I have concerns with putting the bar at a place where enforcement has to take the ride and complete the trip. I mean, many of my impounds were an offer and an acceptance. We did not complete the trip. So I have reservations with setting that bar at that level where enforcement has to put themselves at great risk and take a complete trip in order to facilitate an impound.
No, and Mr. Chetty, I don't disagree with that. This is far and away from that, because there was a crew involved in this. There were passengers getting off an aircraft, so there was no trip to take per se for any enforcement officers. And so I don't disagree with you. I think where my disagreement comes is, what was the nature of this? Who were the passengers? And that's where I'm having some heartburn on this. I'm not going to lie. I'm having heartburn on it because Mr. Barnes, please hold on.
Okay.
Please. I'm having heartburn on this because I still feel that and perhaps it's, I mean, we're going to have to play this out at some time. We're going to have to let it go to court and let a judge decide as to whether those flight crews in procurement are considered part of, if they're just passengers on the aircraft, or they are indeed part of the flight crew. I happen to believe that they're part of the flight crew. Again, having personal experience with a lot of this stuff of organ procurement, and I mean, this is, and maybe I'm too close to this to make this kind of a decision. This is near and dear to my heart, and organ procurement, any interruption in organ procurement is potentially going to cost someone some of their lives. And I want to commend the way that this all went down, just for the way that things were dealt with ultimately, but it could have had a much worse outcome.
I have one more thing to say, please. I have one more thing I must say.
Mr. Barnes?
Okay, so we do many of these. We've done hundreds of these, almost all of them are in California. So what happens is that, let's just say the pilots run out of hours. Let's just say,
Chairman, I'm sorry again.
Can I finish?
Mr. Barnes, said we do hundreds of these. It's not on the agenda.
Okay,
The only one
all right, I want to give you
is
some context.
specific case.
I just want to give you some context.
Mr. Barnes, she is correct.
Okay, here's the thing. So what happens is, if the flight crew runs out of hours, they have to take off or they can't fly. The organ now must go somewhere. So in many cases, we take the organ from the hospital and the person who's got the organ, it's only one person generally, and then we'll drive it somewhere because it can't be flown there because there's no plane that can take it there. The pilots are out of hours. So now,
Chairman,
assuming,
again, this is irrelevant to the case.
No, because we're talking about the second part of it. No,
I have asked
We're
Mr.
talking
Barnes
about
to stay.
You're talking about the second part.
Miss
where you're
Wilburn,
assuming-
Miss Wilburn.
I just want to finish.
Miss Wilburn, just hold on for a second.
I
I'm
just want-
gonna let him just go ahead and complete his
Yeah,
thought.
I just want to, so when this organ comes out, there could be complications. These flight crew, they're limited by hours. Either they have to park the plane and not fly, or they have to fly out of there somewhere else to get somewhere else, and the surgeons are separate. The organ and the person that babysat that organ and that machine, on many occasions, we are then told, hey, you've got to drive this machine and this person somewhere because the plane's not able to take, or it could be weather related. Also, so the second part of the trip is never guaranteed that you even get the second part,
Okay.
or where are you going to go from? And I'll even, like I said before, if the first part was legal, why do we assume that the second part was illegal? But again, we don't even know what the second part was because there was no second part. We were impounded.
All right. Thank you, Mr. Barnes.
You're welcome.
Okay. Anyone else? Mr. Rebar? Go ahead. You have 3 minutes, sir.
Drew Rebar, A&A Towing. I am a certificated carrier in the state of Nevada, CPCN 7209.
Mr. Chairman, I'm sorry, this is not public comment. Mr. Rebar is not a respondent in this case, nor is he legal counsel. He shouldn't be speaking in this case. He wasn't there.
I'm taking public comment right now, Miss Wilburn. Go ahead, Mr. Rebar.
Thank you.
This is public comment.
I believe
That's
I was
3 minutes.
around when this law was put into effect. My industry is a beneficiary of this law. I impound vehicles at the order of the NTA and store them, and we charge a fee and we enrich ourselves. The way I'm hearing things described is the authority is impounding vehicles before the crime is committed. The NTA, by their actions of targeting me with David Gravel and supervising investigator Foster, that's now the chief, lying on the public record, I have great concerns with regards of the integrity of many individuals within the Nevada Transportation Authority in the way that they carry out their jobs, as they appear to target certain individuals. The way that this law seems to have been carried out over my roughly 20 years of experience in dealing with the NTA doesn't always seem to be blind justice. I have a great constitutional issue with the way the Transportation Authority is doing this. I think you have great problems, especially with the Supremacy Clause, and not adopting the federal CFRs that regulate interstate under your DOT numbers, especially when dealing with aircraft and medical cases. There seems to just be a problem here. How is this a benefit to the people of not only our state and community, but the nation, that are having medical issues and need these body parts from somebody that may unfortunately be deceased to go and benefit somebody that's alive and going to hopefully contribute to our overall society and nation? This just appears to be wrong on so many levels. And I believe this all came about in regards to a man named Bob Ferriman years ago. Bob Ferriman went so far to escape the reach of the Nevada Transportation Authority that he went to, where was it? Puerto Rico or wherever, and got a Puerto Rican driver's license so that the Nevada Transportation Authority couldn't take his driver's license away. Then he became a lobbyist and lobbied to our Assembly and our Senate in order to deal with some of the corruption that he found here. I just find that this is, how is this whole thing helpful to the public and benefiting the public? How is it constitutional? And how is it honoring our federal oversight and federal supremacy. And the Transportation Authority doesn't want to adopt these regulations. Thank you very much, Drew Rebar, A&A Towing.
Thank you, Mr. Rebar. You're right on time. You got 3 minutes down. I didn't even have to call you out. That's impressive.
I've been practicing.
Impressive.
And there's NFL teams that could use you.
All right. Any public comment down in Las Vegas, and then I'll go to online.
Members of the audience who wish to comment? There are no members of the audience who wish to comment, Mr. Chairman.
I think we may have someone online. I know we had Mr. Kaplan online earlier who made a comment under general public comment. Mr. Kaplan, are you still online? Would you like to make public comment?
Raised.
There are no hands raised, Mr. Chairman.
Okay, very good. I'll close public comment. I'm going to bring it back to the board. For one last, Mr. Ferendorf, your closing statements.
I believe everything's been said. I don't have anything.
Okay, thank you so much. Mr. Zoka, any closing statements?
At this point, Mr. Chairman, I believe I've said everything on behalf of my client that I have to say. Thank you.
Okay. Thank you so much. Let's go to a motion. I'm looking for a motion either to approve item number 24 or to deny it.
Chair, I'll make the motion to approve item number 24.
Do I have a second?
Second.
I have a motion by Commissioner Teddy, second by Commissioner Gibbons. All those in favor, please signify by saying aye.
Aye.
Those nay, Hartung is a nay. Motion carries 2-1. Okay, that'll take us back to item number 20. Go ahead, Mr. Pasternak.
Thank you, Mr. Chairman. Item number 20 is citation 25344 and 25345 issued to Stephen Barnes for violations of NRS 706.386, NRS 706.758, NRS 706.386, and NRS 706.758 for possible action.
Okay. All right, thank you so much. So I would note for this that the 758s were dropped. They were withdrawn, but Mr. Zoka, I have a conflict here. So I'm in agreement with citation number 25344. I think it was proper. I am not in agreement with citation number 25345, which was the citation that was given for the transportation to the hospital, from the airport to the hospital. The other one was Crystal Bay. How do we deal with that? How do we rectify
You can
that?
do separations, one for one item, one citation, one for the other citation matter.
Okay.
And then, Chairman, I can break the orders up
Okay.
after the fact.
Yeah. No. I'm supportive of one, but I'm not supportive of the other. That's all. I'll be very straight with that. Okay.
And Mr. Chairman, just as you said before, 25345, the one you're not in support of, I don't believe we should relitigate. They are the exact same
No.
arguments in fact we just heard.
No, I'm not looking to relitigate that. That's why I took item number 24 first, so that we could make a determination, so that the board could make a determination on 24, and then coming back to item number 20. But I just wanted to put on the record initially that citation number 25345 that I would not be in support of. So, who wants to open this item? Mr. Ferendorf?
I would just adopt all of the arguments that were previously heard and decided.
Okay, understood. Mr. Zoka?
I would also do the same here, adopt the previous arguments. Thank you.
Okay, very good. Mr. Barnes, would you like to make comment?
You know, if it would make a difference, I would, but since, with all due respect, you know,
No, I understand.
I mean, like, even the Harlem Globetrotters lost 3 times out of 13,000 games, you know? And, you know, I mean, even a broken clock's work, you know, right twice a day. I've run a $100 million company. I have been in court a gazillion times. I've won, I think, 99% of the time because we're good, honorable, decent people. I don't think I've ever come into a venue where it's a fait accompli. It's a done deal before you get here, no matter what evidence you present, no matter how you say it. never the benefit of the doubt, never any gray area. It's always you're wrong and all that. So unfortunately, we're gonna have to litigate this all the way to the U.S. Supreme Court. We're also gonna have to get involved many other federal agencies to adjudicate our position. So I'm sorry about that.
Okay, no, it's Mr.
Very
Barnes,
sorry.
that's your
Very
legal
sorry
right.
about that.
But I would like to remind you that it was not a done deal.
Okay.
I
But
would like to remind you of that it was not a done deal, so I'm just going to leave it at that.
yeah,
Thank
I
you.
do appreciate
Thank you.
that from you.
I would just, if I could just make one comment,
Go ahead.
I apologize. It is just, Mr. Barnes does have his application in for the CPCN, and I'm very hopeful that at some point that can be approved, because I believe that he runs a very fine business for the people up here, and I believe it's in everyone, including the state's interest, for Mr. Barnes to get that license. He's applied. He's been very diligent with following all of this stuff, and if there's any possible way that process can be sped up to all of these hearings and issues involving Mr. Barnes and his company can all be put to bed. And so I'm just very hopeful that is in the process.
I will take that as just general public comment because that does not pertain to item number 20, which is citation number 25344 and 25345. So, commissioners, any questions on item number 20?
For me, Chair.
None for me.
Okay, do I have any additional public comment? I'll start in Las Vegas.
There's no one here raising their hand, Mr. Chairman.
Thank you. Is there anyone online wishing to speak on item number 20?
No one's hands raised online.
Thank you so much. Is there anyone in the room here in Reno that would like to speak on item number 20? I mean, you've already spoke, Mr. Barnes, but I'll give you your 3 minutes if you would like to speak.
Okay, well, that was the one that was the trip from the Reno Tahoe Airport that went to Truckee Airport. And originally it was supposed to go from the Reno Tahoe Airport to Crystal Bay to pick up someone else and then go to the Truckee Airport and drop off. What happened was the person we were going to pick up in Crystal Bay on the continuous trip had a business call that he had to make. So what we did is we took the client from the Reno Tahoe Airport to the Truckee Airport, dropped him off, and then went over to Crystal Bay, waited a block or two away for our client to then finish up with his business and then to pick him up and take him to the Truckee Airport. So when the officers came up, there was no one in my vehicle because I already dropped them off at the Truckee Airport. So any ambiguity about going to Crystal Bay and then picking that client up and continuing on was moot because the trip ended at the Truckee Airport, then I went over to pick up the other client to take him in. And so when they found my car, they found me by myself. There's no one in there. There's no luggage in there. There was nobody in there. Nobody. So I don't know how I could be found guilty of a point-to-point on that.
Okay. All right. I'm going to take you at your word on that, Mr. Barnes. Okay, so instead of splitting this into 2 items, we'll just take a single vote on citation number 25344 and 25345. I'm looking for a motion either to confirm or deny this, to approve or deny.
For 20, citation 2534.
Speak loud.
Citation 25344 and 25345. Those will be
Motion is what, Ms. Gibbons?
okay, motion to approve.
Okay, do I have a second?
I'll second, Chair.
Okay, so I have a motion by Commissioner Gibbons, a second by Commissioner Teddy. We have asked for public comment. All those in favor, please signify by saying aye.
Aye.
Hartung is a nay. Motion carries 2-1.